Right, so last night on Newsnight with Hussein Mohammed, the Director of Public Prosecutions, Nuruddin Haji, expressed his displeasure over the manner in which the courts have been handling cases against high-profile individuals. Citing the example of the case against Migori Governor Okoth Obado, who is facing murder charges, the DPP said the county boss was granted, quote, wanting bail terms by the court. This, of course, he said on the show last night, and he said this, that there must be standards. Listen.
Concerned on this. We have taken cases. We have charged individuals, be they governors or, constitutional office holders or the DCJ herself. My concern is this, that most of them still remain in office. And the sad thing is, we still have orders to allow them to enjoy whatever it is coming from the courts themselves. And some of the bail, for example, in a particular matter case to do with the governor, the bail terms are wanting. Because you saw him making presentation before development partners, international development partners, on issues development. And this is somebody who is facing a murder charge. This is somebody who is facing investigations on corruption. This is somebody who was found with guns, unexplained guns in his premises. I mean, we must have standards. And those standards need to be applied across board. And the courts need to help us. As much as there is zeal to give these people bail, and bail that are, in my opinion, and I stand guided, sometimes wanting, it just defeats the purpose of the whole exercise. When you get conservative orders asking us not to investigate individuals who hold very important offices, it is very sad.
So that was the DPP last night. I'm here with Murigi Kamande, who's a lawyer, to talk a little bit more about this. Murigi, good morning.
Good morning.
Thanks for making the time for us today.
Thank you.
What the DPP was saying yesterday is a sentiment you've heard, I'm sure, amongst a lot of us who are not necessarily in the legal profession, but who are saying, how is it that such a person who is powerful, but was literally granted free bail?
Yes.
And we know the law says that every offense is now bailable. Do you agree with the DPP's sentiments that the court terms were what he says wanting?
Allow me to disagree with the DPP, and I'll disagree with the DPP on one ground. One is that the right to bail is a constitutional imperative, and all offences are bailable. And the basis for that is that under Article 50, Sub-Article 2, there is what we call the right to the presumption of innocence. And that right to presumption of innocence comes with a responsibility under Article 49(1)(h) of the DPP to provide compelling reasons so that a person can be denied bond or bail. And if you look at the circumstance that we have, I do not want to go to the merit. I would not want to discuss the merit of Obado's bail terms. But you could tell that the judge was at pains to try and explain the different conflicting interests, and arriving at the conclusion that two of the accused persons who are charged alongside Obado would be denied bail. Yes, and Obado was granted bail. And the question now that arises is that the ground that he was not one, he's not a flight risk, being a governor. And then if you look at some of the conditions, actually in the legal circles, what we found is that people were questioning some of the conditions.
Yes, and I think perhaps that he was granted bail wasn't particularly the DPP's issue.
Yes.
But it was the terms surrounding it. I mean, and this is what we talk about. I mean, a governor's position is a powerful one.
Yes.
And you certainly you wield power. You have access to resources, even if it's not necessarily financial, but it is to the extent that like we were saying before we went on air, when you walk into the room,
yes.
you know, everybody, you know, takes attention.
Yes.
Could the court
yes.
have granted some stricter terms, which is you are out on bail,
yes.
but you will not perform functions 1, 2, 3?
Actually, I want us to look at it in context. Mm-hmm. One of the conditions within which Obado was released is that he would not go to a certain
20 kilometers from the site of the
yes, from the, is it the Homa Bay?
Yes,
the Homa Bay, of the Homa Bay border, yes,
right.
because he's based in Migori. The other one, and a very strict one, is that he would not address any public rally, any gathering on the issue pertaining to the case that was there. Okay. I do not understand what the DPP issue was all about. And I believe what the DPP was saying is that the moment the governor was charged with the offense, then he ought not to perform any of his functions of governorship. Okay. Considering, let me tell you why, and I'll criticize him for this. He expressed concern that Obado was in a meeting with development partners, right. in a meeting that was not related whatsoever to the case that is pending before court against him.
Let's put the legal aside for a minute.
Yes.
And you're a lawyer.
Yes.
But let's put that aside for a minute.
Yes.
There's an ordinary Kenyan like me who is asking,
yes,
what picture does it present when you have an individual like this accused of a very heinous crime?
Yes.
It's, you know, murder most foul. I mean, we need not go into the details of what happened to Sharon.
Yes.
And presuming his innocence,
yes,
fine.
Yes.
But it's a bit jaunting.
Yes.
And also considering the fact that this case comes up
yes.
for full trial, full hearing. Is it in June next year?
Yes, it comes up in
What does that do for a witness
yes.
who sees this man going about, I mean, and there's nothing wrong. I mean, he's performing his duties as he should and as, you know, as mandated by the Constitution.
Yes.
But I would imagine if I were a witness in this case, I would cower in fear. We have 7 months to go. Here he is. He's doing what he should do.
Yes.
But just without the legal aspect of it, what does this do? Or should the court case have been brought earlier, you know, like finish and dispense with the matter?
Yes.
So that we don't have the governor, you know, doing work for the next 7 months or so before this case is heard and completed. No,
I understand the apprehension.
Yeah.
And it is natural for people to develop fear, especially witnesses, in matters which we are terming as high profile. At the same time, allow me to go back to, because we are a country that is guided by the rule of law.
Right.
That notwithstanding, the burden was on the DPP. It's not on the court. For the DPP to show that he would interfere or would instill fear, for example, in the witnesses. Yeah. Because, you know, what would entail is that once any influential person has been accused of any offense, then naturally they should be denied bail, because there is a very likelihood that they are going to instill fear.
Just by being?
By just being in that position.
Okay.
That can also be a worry. But at the same time, you also have to balance with the rights of these individuals.
Okay.
Yes.
So it's the rights of everyone.
Yes.
All right. So stay with me, because in that same interview, the DPP also said he will seek a change in laws to have all public officials who are facing charges to be out of office.
Any officer within the central government is stepping aside. The ambassadors have stepped aside. They're not in office. They've stepped aside. Their allowances have been chopped off. They're having half-pay salary. That's what if I had my way, and I'm going to ask Parliament to review this, the salaries also have to be stopped altogether. They can be paid later on, lump sum, if they're innocent. But they should not enjoy those proceeds until we finish the process.
Despite them being suspended.
But the issue of the constitutional office,
right,
the issue of the judiciary, not being able to step aside once they're charged, and even if we're in the High Court or whatever other court adjudicating the matter, they should step aside. And it's unfair then to ask the executive, what are you doing about ensuring that there's conviction? What are you doing about people stepping aside when you have these independent institutions not agreeing not agreeing to have the law applied equally to everybody?
Stepping aside, a term that is so infamous in this country, whose meaning is so ambiguous.
Yes.
And this brings to mind
yes.
Mohamed Swazuri, who's the chair of the National Lands Commission.
Yes.
He was given some very restricted things that he could do at the office. I think he would go there with, you know, under supervision. He went to court and was now granted, you know, the authority to go back to work.
Yes.
Stepping aside in this country, he's seeking to change the laws of that for public officials.
Yes. Three things.
Yeah.
One is that stepping aside, for example, is a political decision. And you remember when some time back a politician... He's seeking to make it legal now. Yes, I want to address that. Stepping aside is a decision that a person makes out of their own... conscience, right, yes. That if you feel that you cannot continue holding this public office while you still have that load of that corruption case on your back, then you decide, for the time being, let me move away from the public office, let me conclude the matter, and if I'm acquitted, then I would go back to the office. And that is what happens in very many developed countries and where you have mature democracies. But now, coming back to Kenya, we have what we call the Anti-Corruption and Economic Crimes Act, popularly known as ASECA. And it is what the DPP seeks to amend. One, it provides that all public officers are suspended. Public officers are suspended if they're facing graft charges. Right. So that is the reason why you've seen a situation where you have ambassadors, you have, what do you call, you have PSs are suspended immediately the moment, or even those officers in the public service, immediately they are done what? They're charged. Yes. However, the same law provides that that section does not, or that subsection does not apply to constitutional office holders, whose process for removal is provided for in the Constitution. Right. Now, there lies the dilemma. And the dilemma is this. There is this argument, and I believe it is the correct argument that was made by Swazuri, is that effectively, the moment you granted the orders that had been, the orders that were granted against Swazuri, that should not step into his office, then technically what you've done is to remove him from office without following the procedure that is provided for in the Constitution.
So should the Constitution be changed to allow, I mean, so it's the Constitution versus law, and which one takes precedence over the other?
It is the Constitution.
But if you have, you know, a case like that where an individual is charged with abusing the powers of his office, and then you return him to that office, I'm human. Are you trying to tell me I would not in any way not interfere with the case if I see some papers that I think could be prejudicial to my case? I wouldn't you know, put them under the table.
You see, that is where the dilemma comes.
So what do we do? The
dilemma comes that if you look at, you have to balance now those two. You know, it is always, in law, you have to balance different interests. And that's where now this comes in, that there must be certain conditions that are imposed for that person to return to their office. One of them is that they should not in any way intimidate any of the officers that are supposed have been listed as witnesses. Now, two is that...
You don't think people will be naturally intimidated?
You see, that is now...
Like he doesn't have to do anything, but, you know, he walks around the office and you're crossing paths, eh?
Yes.
Imagine if you were my boss and we're crossing paths, you have been charged with something, I'm a witness.
Yes.
Tukipitana kwa corridor, surely.
Yes, it is a genuine...
You might not even say anything.
It's a genuine
to me,
concern.
But, yeah.
I believe it's a genuine concern.
Yeah.
But also the other thing we also need to look at, is that we cannot have the DPP as the firer-in-chief. Do you know what that means, the firer-in-chief? That one day the DPP and the DCI can wake up and decide to get rid of all the constitutional office holders.
But he's talking about pushing for a law.
Yes, that's what I'm saying. To enable
this happen.
You know what?
And where he says you will not get your salaries.
You know what he wants?
But once you are acquitted, you'll come back and get it all.
You know what he wants? What he wants is, I would say, a situation where the moment you are charged with a criminal offense, regardless of your office, whether it is whether you are, even if you are the Chief Justice, whether you have a security of tenure or not, you have to step aside, you have to leave that office. You do not enjoy any of the perks of that office. Yeah, and that is what he's saying. Because what you have right now is that those officials have the salary and the allowances and nothing else. And they do it for doing nothing. And they do that is that for a period that there is a condition that those cases must be concluded within 2 years. That is
so should we put a clause in security tenure? You know, and so you have the security of tenure.
It's a very dicey.
Only up until moment X.
It's a very dicey situation because you know what it does. It takes away those constitutional protections that we have, safeguards, the constitutional safeguards that constitutional office holders have. For example, I'll give you a case. The Deputy Chief Justice is facing graft charges.
Yes.
Right? And they are contesting, and her legal team is contesting, that these are commercial transactions that have been blown out of context, and now they've been framed as criminal charges. If the law was not such that constitutional office holders were protected, then the day the Chief Justice was, the Deputy Chief Justice was charged, essentially what would have done is that she would have been fired.
Stepping aside.
You know, let me tell you, stepping aside, you step aside for a period of 2 years, right? You'd have quorum hitch, you'd have people taking over. For example, I'll tell you, what you had a situation at NLC is that the vice chair interpreted those orders to her own advantage and decided now that you are out of office, I'm the de facto chairperson.
Okay.
So what would have is a situation where that office holders and independent offices, and it is a very, that's what I was saying, I would be against that. And that protection is necessary, such that you have, you protect the sanctity of the Constitution. That if the Constitution provides that this is the procedure of removal of a constitutional office holder, you cannot have a statute now that wants to come and override that and give somebody the powers to go ahead now and remove people from office.
Murigi Kamande, lawyer, thank you very much for speaking with us. No doubt the statements that were made by the DPP yesterday will continue to elicit reaction.
Yes.
And we will look to that. Thank you very much.
Thank you too.
For your expert insights on this issue.